intro anyway. So good morning, everyone. I hope everyone's staying well wherever you are. Delighted to say the sun's shining this week, which is a great thing. Delighted to be joined today by Sean Randall from Blick Rothenberg. He's here to talk about SDLT. He is actually an expert on SDLT and has recently written a book on the subject as well, which Sean will kind of refer to at a later stage in the webinar. But his purpose today isn't necessarily to plug the book, but to try and give you an overview of SDLT and some of the complexities around it. Now, I will say before we get started, I've already received a number of questions from the participants who are joining us today. So we've had quite a few of those, and no doubt you'll have questions as we go through the webinar. So I'd just like to draw to your attention, within the software, you have the ability to Q&A. There's a Q&A button in the software. If you've got questions as we go through, please feel free to put them in there. I would rather you use the Q&A button than the chat button. And the reason for that is it's unlikely that we're going to be able to go through or get to every single question today. We only have an hour. For those questions that we don't get to, we will follow up afterwards. So if you use the Q&A and remember to enter your name, that'll allow us to then come back to you individually with answers to the questions. Okay, so what we're going to do is, it is a webinar from Sean. We'll then hand over to Luke Sava from InfoTrack, who's just going to show you the SDLT submission page on InfoTrack, which will take about 2 minutes. And then we'll come back to the questions at the end there before closing off. So Sean, if you unmute yourself and you're there, I will mute myself off and hand over to you to conduct the webinar.
Okay, thanks very much for that, Adam. That's a really good introduction. Well, welcome everyone. It's great for you to join me. I'm speaking to you from my front room in the Kent countryside. And unfortunately, the only room in my house that has a stable Wi-Fi connection happens to be by the front door. So anything could happen. I've had to bribe one of my daughters already £5 not to disturb me, but anything can happen over the next 45 minutes. So let's see what happens. So the title, Understanding SDLT, is probably overambitious. I'm not expecting you to understand SDLT after this talk, but it ought to be relevant and interesting to you if you are a residential property lawyer in particular. So a bit about me. My name is Sean Randall. I have 20 years stamp duty experience, mostly at the Big Four. I write another book called Sargent and Sims on stamp taxes, have done so for quite a while, and that work was the subject of an award in the recent past. Let's look at what we're going to talk about. Okay, I thought this would be the most relevant and interesting for you. So we'll start with mixed use, and in particular, in what circumstances the purchase of a country house with some adjoining land might be taxed at the much lower non-residential rates of stamp duty. In other words, 0 to 5% rather than possibly 3 to 15%. So a maximum rate difference of 10%. And we'll look at, in particular, 4 tribunal decisions and understand what they mean, try to draw some principles from those and apply those to future transactions. Then we'll look at annexes and in what circumstances the purchase of a house with an annex, possibly a lower basement flat, might be eligible for a partial relief from stamp duty. And again, there's been 1 tribunal decision on this so far, more possibly in the future. And that was also a win for HMRC. Then we'll move on to derelict or dilapidated dwellings. And similarly with mixed use, we'll look at in what circumstances the purchase of a derelict dwelling might be taxed at those non-residential rates. Here, though, there was a tribunal case win for the taxpayer. And finally, we'll look at some other points affecting reclaims, in particular time limits, future case law, and the possibility of being affected by some professional negligence actions in respect of historic annex purchases. Let's look at mixed use first. Okay, there have been 4 first-tier tribunal decisions over the last year and a half or so. Those are the names. They're all first-tier tribunal decisions only at this stage. I understand that some, possibly all, might be being appealed, in which case, once they are, we will have a decision from the upper tribunal, which would be binding on other cases. So far, those tribunal decisions are only binding on the facts in those cases. But it's pretty striking that so far, a relatively consistent approach has been taken by the tribunal in those cases. So far, the revenue have won every case. And some principles have emerged, which are really quite consistent with the revenue guidance, albeit that guidance was produced after some of those cases. So here are some of the facts involved in those cases, and I took the liberty to drop in some Google map shots of the land in question, such as they are. They give you a bit of an outline of the relevant land, I think. In Pensfold, that is a real photograph, I understand, of the brochure. And in Miles Till, I gave up. The subject of that transaction was a shepherd's cottage, and that's all I could find in Google of a shepherd's cottage. And that, I stress, is not what was bought in that case. So let's look at Hyman. And we'll cover some of the principles in a second, but I just wanted to draw to your attention the facts in these cases and how similar they are, or how common they are to, everyday transactions in country properties. So in Hyman, there was a barn, 3.5 acres of overgrown meadow. That meadow was subject to a well-used bridleway, and that meadow itself was separated from the garden and had been used by the seller to walk their dogs and to keep hens on a kind of non-commercial basis. So that was Hyman, 3.5 acre overgrown meadow. In Goodfellow, we had 4.5 acres of paddocks, and they were used for horses. There were also stables and a stable yard in that property. And the neighbours of the relevant property had paid £1 a month to the seller to enable them to use the paddocks for their horses too. If that wasn't enough, the taxpayer in that case also argued that a room used above the garage as an office for the appellant's business also meant that the property was mixed use. In Pensfold, we have a very large land purchase. So country house purchased with 27 acres of adjoining land. Here, that land was the subject of an all grazing license, so unwritten, probably implied license in favour of a farmer to enable him to graze livestock, probably sheep. Nevertheless, there was no mention of that grazing in the sales brochure. And in fact, the tribunal, as we'll see, drew some inference from the fact that there was no grazing at the completion date. And then finally in Miles Till, there was just over an acre of overgrown paddock, no evidence of non-residential use for nearly 30 years. So these cases might already give you an indication of the type of reaction by the tribunal to the argument that the relevant land in each case was not residential. In other words, it was not part of the garden or grounds of the house. And that was the key thing for the appellants to argue successfully, that the relevant land in each case was not part of the grounds of the house. So I think this slide, starting in the top left, tries to draw together some of the major principles established in those cases. So in Hyman, which was the first case, the tribunal held that grounds in the SDLT legislation wasn't defined, therefore took its ordinary dictionary definition, and they felt that it would be reasonable to say that land surrounding a house, which is either occupied or available to the owner of the house to use, constituted the grounds of the house. So a very wide meaning was given to grounds. And that part underlined, I think, is really important. So in some of those cases that we've just discussed, the land in question wasn't actively being used by the owner of the property. Nevertheless, the tribunal held in Hyman that the fact that the land was available for use by the owner was important and meant that the land was part of the grounds of the house. They also held in Hyman that the fact that the land was separated from the gardens wasn't relevant, nor was the fact that the land in question had a right of way. Okay, let's skip to use. And I think I've mentioned this already, but just to underline the point, some argument was made in that case that the land had to be used for ornamental or recreational purposes. And the tribunal found that wasn't the case. It didn't need to be actively used either for either of those purposes or any purpose really. The fact that it was available for use by the owner of the house was important. And unsurprisingly, the appellant in Goodfellow didn't persuade the tribunal that a home office was sufficient to prove that property, the main house, was mixed use. If we move down clockwise, down to evidence, Goodfellow and Pensfold are cases which really underline the fact that the tribunal was very interested in what the sales brochure and the sale contract said. And they drew inferences from the fact that the relevant documents in those cases did not mention the existence of any grazing. And there's something to take from that, I think. And I guess the point the tribunal is making is that information would have been, would have informed the buyer's decision about what they were purchasing. And if the buyer was aware that they were purchasing land that was subject to grazing, well, that might strengthen the argument that that in fact is what he was buying. It also underlines the fact that, some pretty informal use by another person, such as the neighbours in, I think it's Goodfellow, about the use of the paddock for their horses for £1 a month, wasn't a commercial undertaking. And we'll come back to that, I think, in a second. Probably a really important case is Miles Till, and there the tribunal confirmed that there wasn't a limitation on size as there is for principal private residence relief for capital gains tax. And so therefore it's not right to say that land which is demonstrably not needed for the reasonable enjoyment of the house therefore fell outside the meaning of grounds. But the tribunal indicated that in some cases an extensive part of land relative to the dwelling might be determinative or relevant to determining whether the land was grounds. So disproportionate size might count But as you can see in Miles Till, the land in question there was 27 acres, and that wasn't felt to be disproportionate. And then finally, if we go to function, I think this is probably, if you were trying to define this subject and work out where the boundary is for determining whether land bought with a house constituted part of the grounds of the house, this is probably the one factor that encapsulates a lot of what was, said in the other cases. And that is, ask yourself, does the use or function of the land support the dwelling, or does it have a self-standing function? And in Goodfellow in particular, reference was made to the character of the property in question and the fact that it was equestrian, and that land was needed to enjoy the property in terms of its privacy and security. And the mere fact that the land might be what's called a treasured view from the house might be enough to say that, it supports the dwelling. So really, to pull that together, do be aware that this is a high hurdle. So land bought with a dwelling, particularly if it's adjoining to the dwelling, there's a high hurdle. The taxpayer will be on the back foot in establishing that the land isn't part of the grounds of the house. The burden of proof, for sure, is on the taxpayer, on the purchaser. And they will have the evidential burden to prove that the land isn't part of the grounds. Evidence is vital, therefore, so do take photographs and retain evidence on the day of completion. Not sure that a grazing license, particularly if it's unwritten and pretty, for nominal consideration only, I'm not sure that's going to be enough. The fact that the land doesn't, or the license rather, doesn't exclude the owner of the house from taking possession, which is inherent in the concept of a license, I think is a strong argument available to the revenue to say that a grazing license doesn't mean that the land isn't part of the grounds. You really need to show, to be safe, you really need to show some kind of active, genuine commercial use or separate function. All right, let's move on to annexes. So highly topical. As you can understand, the purchase of an annex, rightly or wrongly, in other words, whether this was deliberate or inadvertent, whether this was the real purpose of the SDLT relief in question, multiple dwellings relief, doesn't really matter, I think, because it's clear that annexes in some cases would count as separate dwellings and therefore would access or engage this partial relief. And that relief is really valuable. It really gives you a significant saving in some circumstances. But the real test is, at completion, is the relevant part that's described as an annex suitable for use? Those are the key words, suitable for use as a single dwelling. And these are the things that I think reasonably the revenue take into account. So in determining whether part of a house, an annex, a lower basement flat perhaps, is suitable for use, look at, in the first instance, those physical facilities. Does the relevant part have a kitchen, bathroom, independent control of heating, electricity, water? Is there an independent entrance? If there's internal access only, or if there's internal access generally, understand whether that's, lockable and could create a barrier to give the occupants of both parts adequate privacy and security. And that was important in the one tribunal case that we'll see in a second. Then possibly the existence of a separate address or postbox and receiving separate utility bills in respect of the annex is relevant. Restrictions on use in the title or planning permission undoubtedly, I think, would be relevant but not determinative. Similarly, if the relevant part that's described as an annex is separately assessed for council tax, that would be relevant. And again, it's important, I think, to understand that marketing is probably going to be used as evidence by HMRC and the tribunal. So emphasis on physical suitability. I stress that there's emphasis on physical suitability, but legal suitability for separate use, I think, is also relevant. Let's look at that tribunal case. So earlier this year, taxpayer in that case argued unsuccessfully that the purchase of a house with an annex, tried to argue that a purchase of a house with an annex qualified for multiple dwellings relief. Now, the annex in question was connected to the main house by what the tribunal describes as a short open corridor. And the end of that corridor, at one end, the end next to the house, there were what's called door jambs. And I learnt after reading this case that door jambs refers to, you know, the frame in which a door may be hung. But importantly, there was no door fixed to that door frame. But the annex did have its own external access via French doors. And the annex did not have its own postbox, council tax bill, or utility supply. I've just been joined by my dog, who is likely to bark at any time. All right, so what was the decision? Well, perhaps not unsurprisingly, the tribunal held that the annex didn't qualify for the relief. It wasn't suitable for use as a separate dwelling. And that's because, in particular, it lacked an internal door. Now, the tribunal held that the absence of that internal door, even though there was door jambs in place and such a door could be hung, meant that the privacy and security of the occupants of both parts would be compromised. It wasn't enough that the occupants of the annex could be a relative, and therefore there could be a trusting relationship between the occupants of both parts. Nor was it enough, the tribunal held, that installing a door post-completion was simply a matter of repair or restoration. They found that installing a door was actually creating a new physical feature. And as I mentioned before, reference was made in that tribunal decision to marketing. So just before we leave annexes, I guess it's important to understand that this is, like mixed use, a relatively fluid topic. More cases are likely to be heard. It's very fact sensitive. Do pull the facts and stress test any assumption or claim that the relevant part of the house or land constitutes a qualifying annex. Do take an informed decision, therefore, before proceeding with the basis that that valuable relief is available. Okay, let's look at derelict or dilapidated dwellings. So the question here is, in what circumstances would the purchase of a dwelling that's dilapidated or derelict, in what circumstances would that be treated as non-residential? Would it retain its character as residential property? So usefully, importantly, the tribunal held in the one case heard so far on this subject that in some circumstances, such a dwelling, if it is in fact uninhabitable at the date of completion, would be treated or taxed as if it were non-residential and therefore eligible for the much lower rates of tax. But what counts as derelict or dilapidated? Well, this was the case last year, first tier tribunal case. All the cases I've referred to so far have been first tier tribunal cases only. This one was called Bewley Limited, and there is a photograph of the bungalow in question. Now, you can't see the inside, but led to believe that the bungalow was uninhabitable. So it was bought by the company, Bewley Limited, with the intention to demolish and rebuild a new house on top of the plot, and planning permission had been given for that demolition and build. So at the completion date, the property was connected to, water, gas, electricity, the usual utility services, but importantly, the copper pipes for, I suppose, heating had been removed, as were the radiators and as were the floorboards. Also, really importantly, the demolition survey carried out by the buyer showed that the property had asbestos and ranked the risk of damage or injury caused by that asbestos being 6 out of 10 or up to 6 out of 10. And the recommendation was for that asbestos to be removed before anything was done to the property. And there was evidence in that report, therefore, that simply restoring this property to make it habitable would have meant significant structural alterations to enable that asbestos to be removed. Bewley, the company, paid tax at the standard rates. And in fact, if it was residential, it ought to have paid tax at the surcharge or higher rates, that 3% top up, which applies to purchases of dwellings by companies in all circumstances. So the revenue challenged that self-assessment on an inquiry. Bewley appealed. And the tribunal held that the dwelling wasn't suitable for use at the completion date, which is the key criterion for determining whether a building is a dwelling. Either it's used as a dwelling at the completion date, clearly this property wasn't used, or suitable for use, and the tribunal held on these facts that it wasn't suitable for use as a dwelling, or it was in the process of being converted or adapted for such use. And again, there were no building works in progress at the completion date to suggest that it was in the process of being adapted or converted back into residential use. But is this fact specific, or does this set a precedent for other cases? Well, I think again, there's a high hurdle. There is with all of these cases, I think. And particularly here, if the property was used as a residential property, is intended to be used as a residential property, has planning permission exclusively to be a residential property, well, it probably retains its residential status unless a significant amount of work is required to make it demonstrably habitable. And in this case, the lack of radiators, pipes, and the asbestos being present in the property all prevented those kind of structural repairs. And therefore the tribunal held that it wasn't suitable for use. And the result of that, ironically, was that the appellant paid less tax by virtue of the revenue appealing, or sorry, by virtue of the revenue making an assessment, because less tax was payable under the non-residential rates than under the standard rates that the company had paid. A couple more points. Tribunal understandably stressed that the fact that the property was unmortgageable wasn't determinative. In fact, they argued that it was irrelevant. Again, the burden of proof is on the appellant to show that the property in question was objectively uninhabitable at the date of completion. And probably crucially in this case, the purchaser was able to rely on photographs of the internal part of the property to demonstrate how unsuitable it was. And again, the revenue argue, as I mentioned before, I think reasonably, that if in fact a residential property lacks something to make it suitable for use. Perhaps it lacks a bathroom or a toilet, or has a hole in the wall, or I don't know, something that is relatively immaterial. Maybe a hole in the wall isn't a good example, but you get the idea. If works could be done to restore residential use relatively easily and cost effectively, then the revenue would argue that it retains its character as residential, even if it's unsuitable for use on the completion date. And they argue conversely that if the extent of the repair or renovation works means materially changing the structural nature of the property, well, then they would argue or accept that it was non-residential at the completion date. Okay, last topic. Let's talk about reclaims, or some aspects of reclaims. So this is, I guess, the term used to describe the act of applying for a repayment of SDLT from the revenue where a mistake has been made. Either a relief hasn't been claimed, or perhaps the right taxes haven't been used, the right rates of tax haven't been used. And here there's a distinction. So where you're making a reclaim because you failed to claim a relief, such as first-time buyer relief or multiple dwellings relief, you have 1 year from the completion date to amend your return to retrospectively reclaim that tax. And there's a tribunal decision this year called Secure Services, in which the tribunal confirmed that was the answer. Just jumping to the last bullet point though, it's interesting that the tribunal didn't talk about the exception to the one limit rule where an inquiry is opened, which was the case in Secure Services. So where the revenue opened an inquiry and you, during the course of that inquiry, but more than 1 year after the transaction, wish to claim a relief, well, the legislation appears to permit the purchaser from switching, perhaps from mixed use to multiple dwellings relief, provided that the inquiry is in progress, which wasn't argued, I think, unfortunately, in Secure Services. But generally, time limit for relief reclaims 1 year, possibly unless an inquiry is opened, but in progress. Then for other reclaims, so where you've used the wrong rates, possibly on a mixed use purchase, you've got 4 years, but remember that that 4-year reclaim process has a different procedural set of conditions, and there are some carve-outs for the revenue in not having to repay tax. For example, where the error was consistent with a general prevailing practice at the relevant time. In terms of future case law, well, I've mentioned the possibility that there will be more case law, certainly on mixed use, probably annexes, possibly on derelict dwellings. But I do believe that there's likely to be tribunal decisions on whether the existence of a reservation agreement entered into by the buyer over a dwelling means that the purchase of that dwelling is a mixed use transaction. Also, I think there's likely to be another decision on the substantive point. So there's already been a decision in Troy Homes, again, first-tier tribunal, on a procedural point, which is relevant to this, but I'm expecting a case on the substantive point, which is this. In what circumstances does multiple dwellings relief apply? Can it be claimed? Where at the relevant date, the completion date, no dwellings exist, but perhaps there's planning permission for dwellings to be put on the land. And I'm also expecting a decision at the first tier tribunal soon on the eligibility of reclaiming that 3% surcharge where the buyer buys 2 adjoining properties and after completion amalgamates them into one combined house could, as the taxpayer is arguing, I think in that case, could the taxpayer successfully argue that both purchases of the two adjoining properties counts as a replacement of a main residence? And then finally, a couple of points on actions. So I understand that some professional negligence claims or actions have been brought against conveyance solicitors for failing to advise on the availability of multiple dwellings relief on their clients' purchases made on annexes or houses with annexes pre-2016. And that's a difficult subject, and obviously we need to see where the litigation goes, and it's fact specific. But there are arguments that, certainly there are arguments that the conveyancers, hopefully this won't be you, but the conveyancers affected weren't negligent in failing to point out the availability of that relief for transactions that predated the surcharge, so transactions which completed before 2016. Okay, as Adam mentioned, a small plug, cheeky plug for a book. If you found anything that I've said interesting, relevant to your professional practice, do check out this book. I wrote recently. It's published by the Law Society. It's available to order. It's really specifically designed for non-tax lawyers understanding what I think is a really difficult subject, and it's covered with examples, warnings, and tips. And I think it will be hopefully really user-friendly and really important on a daily basis. So do check it out. So thanks for your attention. So before we go to questions and answers, I'm going to stop sharing my screen and hand back to Adam.
Thanks, Sean. Yeah, quite a few questions actually coming through, so we'll go through those in a mo. Excuse me. Luke, if you unmute and share your screen and just give people a quick overview of the SDLT on InfoTrack.
There we go.
And then I'll come back to the questions.
Brilliant. So first of all, thank you, Sean. That was a really, really good run through, interesting and informative on what we all know is quite a complex part of the conveyancing process. So what I'll just show now very quickly is how we at InfoTrack have tried to simplify this as much as possible. So first of all, you'll see that our SDLT form, it does fit into one page. So this is quite different from lodging these applications through HMRC's direct website. So at the moment, you can see that all of our text boxes are completely empty. And one of the main benefits of using the additional services through InfoTrack, which you might see just across the ribbon at the very top of the page, is that as you order additional products outside of InfoTrack, they do begin to pre-populate the form. And as I type in a matter reference and just click here, you'll see that it retrieves the matter information, and the majority of this form begins to be completed for you. So the property details would have come through if you'd issued searches through InfoTrack or if you had ordered office copy entries. Again, you'll see that vendor information here has also been completed as copied over from the office copies. An additional vendor, as we go down, you'll also see that the purchases information here, where you're using InfoTrack for onboarding and AML. And that is the simplicity of the form. I'll just run back to the top and just show you a few of the fields that would need to be completed to allow for an SDLT to be submitted. So we'll select the transaction description. So we'll just put this as a standard transfer. Your effective date, or most likely your completion date, you need to be selected. Then we'd ask a few additional questions about the property details. So we'll look at the property type, and as Sean alluded to, this is where your assessment's required. We'll just click a standard residential here. you'll also have to assess the interest transferred in this transaction, and simply pop in the consideration being exchanged here. So I'll pop in just any figure, select the consideration form, and ask the form to calculate. So at this point, we do pull up a calculator, which is the equivalent to that at HMRC, but reactive with the form in the background. So as we see here, we've got the consideration, we've got the transaction type, which we selected previously, the property type also selected, and additional questions to help you calculate the tax on this transaction. So as you can see, the tax has been calculated just at the bottom. By clicking update, we can populate this back into the form. If we do want to change anything about this, so we'll click calculate again. And for example, we had selected a residential property type, but actually this is a buy to let or a purchase of a second home. So I'll select this radio button at the far right hand side, and you can see that that will automatically elevate that to the higher rate. Additionally, if we stick to residential and we go through and answer the questions as if our client is a first time buyer, so purchasing the property as an individual, not resulting in owning 2 or more properties, and not owning another property as a main residence, you'll see that that has now reduced the tax to be paid on this property. So I'll go ahead and update that. In it goes into the total due, and then we would type that again to say the amount being paid to HMRC in this instance. As we continue down the form, we'll see that again the vendor's there. And when we see the vendor agent details, we can also start to select a firm's name. Let's just pick any, and that will pop along to a law society database that we have in the background, and then include that firm's address to be included in your HMRC submission. So again, we look at the purchaser. Another nice little quick link that we have on InfoTrack is you can copy the primary property. Where this is a standard residential transaction or even a commercial, you can just copy that address from earlier on in the form at a quick click of a button and include your client's reference. So here we can include your national insurance number and their date of birth to allow you to proceed through the form. And that essentially is an SDLT completed very, very quickly. And some of the amendments can be made. So adding additional vendors, just in a blue text underneath the vendors. And the same with the purchasers. We can add an additional purchaser. As we know, that happens in many transactions. They might pop up throughout the process of ordering searches or doing your due diligence. Another client will be included. I'll include that. And that's simply a very easy residential SDLT ready to be submitted. So I'll go ahead and submit that. And you'll see that our validation stops you submitting an SDLT without valid credentials, so without a valid NI number or other issues if they do present themselves. So I'll save this as a draft here, and it creates a nice document that can be shared with your client and signed, or even take advantage of our current free Sign It tool. Send that off to a client to sign a declaration at the very bottom to say that they are happy with the information provided. Once this is submitted, the SDLT file will be returned immediately on your screen within a few seconds, and also by email and saved in your InfoTrack matter. I hope that has covered that for you. If there were any other questions, I'm going to pass you over back to Sean now, who will answer your specific questions based on the webinar just given. And if there's anything else, I'll hang about and we'll make sure that your account managers follow up with you on the product. And if you need any training or if you'd like being introduced to our SDLT form, we'll follow up with you over the next couple of days. I hope you'll have a lovely day, enjoy the weather, and stay safe. Thanks. I'll pass that back to you, Adam. Stop sharing.
Yes, okay. Yes, there's some questions coming in here, which we won't get through all of these, Sean, but we will follow up with each and every individual question. Some of them go back to the presentation, which we didn't have time to answer. But let me start with question 1 for you, Sean. So I'll read this out. My client completed their purchase of a single property. It used to be a joint property and still has 2 kitchens, 2 front doors, 2 lounges, etc. The property is used as one property and we completed the tax on that basis. A month or 2 after completion, my clients have received an approach from a company who have advised that they can save them thousands of pounds by reclaiming the tax, as it should have been taxed as, presumably, 2 residences with the additional dwelling relief. Is this correct? And should we now be reclaiming the money? If so, what is the basis? I've spoken to the HMRC and they are not helpful after the event. That sounds about right. I won't read out who's written these questions, maybe a little bit unfair, but over to you, Sean, can you answer that one?
Yeah, hi, thanks Adam. So good question. And, you know, the possibility of receiving, or your clients receiving letters from unsolicited you know, reclaim boutiques is very high. So there are many boutiques that proactively look at the land registry for recent completions and write to the buyers on an unsolicited basis, offering to reclaim tax. And, you know, in some cases, their arguments are valid and entirely correct. And in some cases, they're punchy at best. There isn't a clear-cut answer in this one. I'd want to stress test more facts than have been outlined, but the simple fact that at the completion date, if this is right, the properties bought were independently suitable for use as dwellings. So let's say if there was internal access that could be locked and the privacy and security of the occupants of both parts wouldn't be compromised, then yeah, on the face of it, multiple dwellings relief would have been available. And the fact that it's not used as such post-completion isn't relevant. That's an important point. So the fact that it was intended to be bought for use as a single property, single dwelling, doesn't matter, provided that physical works aren't done to either part of the property to render it unsuitable for use as a single dwelling. So let's say, you know, within 3 years, because there's a control period of 3 years under this relief, if within 3 years of completion, the buyer took one of the kitchens out, or, you know, the bathroom out of the relevant part that was originally one dwelling, well, that would result in a withdrawal of that relief. So intention alone doesn't matter, but physical works post-completion might. But on the face of it, there may be an argument there that a relief, the relief could be available. But remember that it's a 1 year reclaim opportunity, or one year reclaim period for that one, I think.
Wonderful, thank you. Okay, so this probably has some bearing on the next question actually, which is if a company paid 15% tax on purchase as director, and the director was going to occupy, then he actually let it instead, can some of the SDLT be reclaimed? So circumstances have changed between purchase and actually what you then decide to do with it, I think is the question there.
Yeah, so that's a good question. That's not specifically relevant to what we discussed. So this relates to the incidence of the flat 15% super rate, what I call anyway, the super rate of SDLT for purchases of dwellings worth more than 500,000 by companies and other non-natural persons. And from recollection only, wasn't something I prepared for, but from recollection, in order to claim that relief, I think the company must intend that the exclusive purpose of the acquisition was development or letting or another qualifying purpose. So unfortunately, my initial view is that if the original intention on the part of the directors of the company was to make it available to what's called a non-qualifying individual, then the relief can't be claimed. The relief, in other words, the exclusion from the 15% rate. And then if the company changes their mind and actually starts making it available for a qualifying purpose, well, that doesn't enable the company to retrospectively change their self-assessment, because the test for that one is at the date of completion. What was the intention on the part of the buyer, in this case the company, in terms of what they intended to buy and use that property for? So I think I'm sympathetic, but I'm not hopeful that the legislation permits a reclaim in those circumstances, but happy to follow up with the individual who asked that question afterwards.
Fantastic, thank you. Another question, it's a bit more specific, Sean. So let me just read this out, it's quite detailed. The date of the sale of a former residence was the 9th of November 2018, and we submitted a claim on 16th of October 2019 within the 12-month statutory time limit. It was sent by normal post to the usual address. We then sent a reminder letter of the 30th of December, and our client eventually received a response saying his claim was received on the 2nd of January, referring to our chase-up letter of the 30th of December, and was therefore out of time. I have explained to the HMRC that we had sent the application within the time limit and asked that they accept our assertion. I mentioned that I had issues with post being lost by the HMRC on another matter, which I eventually resolved by sending the application by recorded delivery, and suggested that if they were unwilling to refund us, they should commence an internal investigation into lost post and accept my letter as a formal complaint. A response to this complaint was swiftly given, simply reciting the previous letter my client had received, advising that their records show it was received out of time and they were therefore unwilling to repay it. The letter was advised we can ask for further review by a different customer service advisor, but I'm inclined to ask questions first about what they've actually done to investigate. What is your opinion on this? Should they proceed down that route, or is there a different route that they should take?
Wow, what a question.
Yeah, sorry, detail.
So I think the nub of that one is that they tried to reclaim within the 1 year period and did so, but the letter making that reclaim application was not received by the revenue, and the revenue then have argued that a subsequent reminder letter made by the claimant was out of time. I think that's the question, and if that is the question, then it is a pretty unfortunate chain of events or set of facts. But I would instinctively go to the Interpretation Act, and I think there's a provision in it. I think it might be section 7, but have a look, which has a presumption that where something is posted, there's a presumption, unless rebutted by evidence on the part, in this case, on the part of the revenue, that it's been validly received and posted. So if, I'm not sure that that provision itself does enough to demonstrate that the correspondence was originally posted, but it should certainly be looked at, and hopefully it does have that effect in persuading the revenue that the original letter had been sent but not received. I mean, there's a salutary tale there, isn't there, of using registered post or recorded post to demonstrate that something has been posted. But yeah, I would look at the Interpretation Act for the person asking that question, and don't give up. I would, request a review, put that argument in the context of the review, and see where that goes. And again, more than happy to help offline if desired.
I think my experience of the HMRC is you just have to keep pushing them until they kind of give in to some degree, as much as anything else as well. Okay, this another question, Sean. What are your views on claiming MDR if a separate dwelling with planning permission is in the process of being constructed or adapted for use as a dwelling on the effective date of the transaction?
Okay, so this refers to one of the three alternative limbs of what constitutes a dwelling for SDLT, for stamp duty. So either it's used as a dwelling, it's suitable for use as a dwelling, or in this case, the third alternative, if at the completion date, it's in the process of being converted or adapted into a dwelling. And those words in the process of aren't defined, haven't yet been the subject of case law, but possibly might in the future. In my view, they require some kind of physical works to have started and be ongoing at the completion date. So the mere fact that, and this is my personal view only, I should say, but the mere fact that land has been bought with the benefits of planning permission and there's a genuine intention on the part of the buyer to develop the land in accordance with the planning permission, to put dwellings on it, I don't think is enough. That might be tested, as I mentioned. I think that was raised in Troy Homes, which I think was meant to be a lead case on this issue, whether the acquisition of bare land with planning was enough to demonstrate that something qualified for MDR. So absent another decision to the contrary, I think if physical works had started, yes, you can argue that a building was in the process of being converted or adapted into a dwelling. But the mere fact that there's planning permission, even if that permission is enacted after completion and dwellings are put on the land, I don't think is going to be enough.
Okay, thank you. I think we've got time for one more question. There are more questions from people, so thank you very much for your questions. And what we will do is we will come back to you on all of these questions. It might take us a few days because there are so many, but let's go with this one, Sean. Purchase of a main property and a separate access, multiple dwelling relief claimed at time of completion. Property is now being made into one property by joining the two together. What is the process for paying back multiple dwelling relief to the HMRC? Is there a time consideration, i.e. notifying HMRC of the change, payment of tax to be refunded, etc.?
Okay, thanks, Adam. So it's really good that someone has spotted that there is an obligation to pay back the relief that was legitimately claimed originally on the purchase, because as I mentioned in the talk, the act of making one of the dwellings not suitable for use as a single dwelling, and therefore combining two dwellings into one, would result in a clawback, if you like, of the relief. And the process, well, the legislation says make a return, possibly using the pretty wizzy software that Luke demonstrated earlier. So make a return, pay back the tax within the return. It's not clear, I think, from recollection that from the return itself, that this would be a return repaying tax that had been claimed. I can't recall seeing a box which says or asks, is this a clawback return or something similar? So I would fill in the return as best as you can, but in particular, write a letter, probably quite a short letter to the revenue, cross-referencing to the SDLT return made and explaining that the return delivered was in respect of a clawback event. You've got 30 days to make that return, the clawback return, I call it now. Make the return within 30 days and pay the tax within 30 days. Otherwise, late filing penalties and interest would start to accrue.
Okay, thank you. Actually, we've got time for just one more question, which someone's posed here. Sean, how much is the book?
I can't recall, genuinely. I think it's slightly more than £100, but go to the Law Society website. I'm not in control of pricing.
Okay, good stuff. Thank you. Okay.
Thanks for asking that question.
All right. Thank you, Sean. Thank you, Luke, for also performing that. There are lots of questions. There will be a recording of this webinar that I'll make available probably tomorrow. We will come back to all the questions over probably the next sort of week, because obviously I think Sean got quite a few to kind of respond to here. So we will come back to you. Thank you very much for your time to the panelists, and thank you very much to the time for all the participants who have joined today. I hope it was useful. If there are other elements of SDLT where you'd like a more focused webinar, do feel free to contact myself, adam.bullion@infotrack.co.uk, and I can set those up alongside Sean. So thank you. I'll now close off the webinar. Sean, thank you. Luke, thank you. And I will see you all later. Goodbye.